Hello and welcome to Blackstone Solicitors YouTube channel, and today we're delving into a topic that no director ever wants to face, but one that's absolutely critical to understand. Your duties when your company is facing insolvency. It can be a turbulent time, filled with stress and uncertainty, but knowing your legal obligations can make all the difference. So, grab a cup of tea and let's navigate this stormy sea together. Running a business is full of challenges, and sometimes, despite your best efforts, financial difficulties can arise. Here at Blackstone Solicitors, based right here in England, we've seen countless companies navigate these difficult waters, and we know that understanding a director's duties when insolvency looms is paramount. Getting it wrong can lead to serious personal repercussions. Ordinarily, a director's primary duty, as we've discussed in previous videos, is to promote the success of the company for the benefit of its shareholders. However, when a company faces financial distress, there's a crucial shift in this focus. Once a company is insolvent, or nearly insolvent, your duties primarily switch to acting in the best interests of the company's creditors. Why? Because it's their money that's at risk. This means your decisions must prioritize preserving the company's assets for the benefit of those owed money, rather than trying to salvage the shareholders' investment. This isn't just a suggestion, it's a fundamental legal obligation under English company law. So how do you know when this shift occurs towards possible insolvency? It's not always a sudden alarm bell. A company is generally considered insolvent if it cannot pay its debts as and when they fall due, which is called cash flow insolvency. Think of it like running out of petrol in your car. You can't move forward, or its liabilities exceed its assets, known as balance sheet insolvency. This is like having more debts than things you own. The moment you suspect, or reasonably should suspect, that the company is insolvent, your duties as a director change immediately. Delaying action can be incredibly dangerous, leading us to our next crucial point: wrongful trading. This is arguably the biggest personal risk for directors when a company is facing insolvency. Under the Insolvency Act, 1986, if a company goes into insolvent liquidation, and it appears that a director knew, or ought to have concluded, that there was no reasonable prospect of the company avoiding insolvent liquidation, and they continued to trade, they could be held personally liable for the company's debts from that point onwards. Imagine continuing to take on new orders, incur new debts, or pay certain creditors over others when you know the company is effectively bust. That's wrongful trading, and the liquidator will be scrutinizing your actions very, very closely. The courts can order you to contribute to the company's assets, which means using your own money to pay creditors. Beyond wrongful trading, several other duties become critical. Duty to minimize losses. You must take all reasonable steps to minimize losses to creditors. This might involve ceasing to trade, cancelling orders, or seeking immediate professional advice. Duty to cooperate with an insolvency practitioner. If an administrator or liquidator is appointed, you have a legal obligation to provide them with all necessary information and assistance. Hindering their work can lead to serious consequences. No preference to creditors. You must not pay off certain creditors, like friends or family, or even yourself in preference to others. All unsecured creditors should be treated equally. This is known as a preference and can be clawed back by an insolvency practitioner. No transactions at undervalue. You mustn't sell company assets for significantly less than their true value, as this depletes the pool of assets available to creditors. The moment you suspect financial difficulties, the single most important step you can take is to seek professional advice. Do not delay. That's all for today's essential guide on directors' duties during insolvency. We hope this has been informative and helpful. If you're facing these challenges, please don't hesitate to reach out to us at Blackstone Solicitors. Don't forget to like this video, subscribe to our channel for more crucial legal insights, and hit that notification bell so you don't miss our next upload. See you next time.